welcome everybody to the second interview in the ADNDRC interview series with leading practitioners in the domain name dispute resolution field. I'm really privileged and pleased that we are today joined by Mr. Ho-Hyun Nahm, who's a leading practitioner at BARUN IP Law and a lead partner at the firm based in Korea. As many of you may know, Mr. Nahm is a patent and trademark attorney, and he's protected the trademarks, designs, and patents of some of the world's leading brands, including possibly my favorites, that's why I mentioned them, Jimmy Choo, Nike, Esprit, as well as a broad range of multinationals, gaming producers, and others. So we're certainly with an individual here who has extensive experience in the field of IP protection. For today's discussion, we will be focusing on Mr. Nahm's extensive experience, thoughts, and views on dispute resolution in this space, and in particular, domain name dispute resolution. When we talk about Mr. Nahm's experience in domain name dispute resolution and arbitration, we can say that he's rendered over 800 decisions to date on domain name disputes and IP-related arbitration cases. Currently an active panelist on the ADNDRC panel, I'm pleased to say. Also WIPO, and also the National Arbitration Forum and the Czech Arbitration Court. For arbitration work, the HKIAC, as well as the KCAB. So we're certainly going to hear from a leading IP practitioner who has abundant experience in dispute resolution and domain name disputes. Mr. Nahm has also served formally as the chairman of the Korea Internet Address Dispute Resolution Committee, KIDRC, and is currently, amongst many other roles and titles, the president of the FICPI Korea Group. So with that, I would thank you again, Mr. Nahm, for joining us today and for sharing some of your input and insights based on your extensive career. And I have a few questions for you, as you know. So perhaps we can just start with, given your experience and the fact that you're a leading practitioner in the field, we take a step back. What originally sparked your interest in IP and in particular domain name dispute resolution?
It has been almost 40 years since intellectual property drew my attention, and I decided to become an expert in intellectual property law. That time I was inspired and envisioned by a rapid wave of industrial changes toward the information-oriented society, and thus intellectual property would become one of the most essential survival strategies for the 21st century. Intellectual property cannot become one's property, no matter how much effort is invested in its development, unless the related rights have been properly acquired. A unique design, a modest idea, an effort to improve a daily routine, the letters in one's own name or a domain name can still be recognized as a valuable IPR. These days, almost everything in the world is done in a virtual space. Domain name refers to the door plate and internet address of the virtual world, the very space on which the games are downloaded and where online shopping mall, also known as the internet marketplace, personal homepage, and company's website actually operates. The special characteristic of this internet address lies in its uniqueness. It is the only one in the whole world. It is possible for identical trademarks that are used on identical goods to exist in each country, independent of one another. However, internet address don't work that way. Now it is common for people to locate their desired cyberspace by conducting a search of keywords through a portal site. But when the internet address is easy to remember and is identical to the actual name, people can enter the site by directly typing in the address.
I think you showed incredible foresight 40 years ago when it occurred to you that the internet and email and domain names would form an important part of IP protection for the 21st century. I mean, when we speak about domain name dispute resolution, it's one of the options that are available to trademark owners for brand protection. Why do you think that domain name dispute resolution as a method for dispute resolution has an important place in the world of options you have available to resolve domain name disputes?
There are lots of merits in using an alternative dispute resolution option for trademark owners and for brand protection. One of the most difficult tasks is how to enforce the decision across territorial borders. In light of the international nature of domain names, the most key advantage of ADR option for domain name dispute resolution lies in right here, that the decision can be readily enforced without regard to territorial borders. Domain name disputes can be rapidly resolved for reasonable cost through alternative dispute resolution ADR rather than procedures of courts. The institution that is responsible for coordinating the maintenance and procedure for GTLDs is the Internet Corporation for Assigned Names and Numbers, ICANN, who has adopted a Uniform Domain Name Dispute Resolution Policy, UDRP. UDRP requires, as a condition to registration, the domain name application to adhere to UDRP procedures on dispute resolution. In the event there is an issue with a third party in connection with the registered domain name, relief comes only in two forms. One is cancellation, and the other is transfer of the domain name registration. Once a decision is rendered, it is binding regardless of whether either party is satisfied or not. Unless a party files a complaint before a court having jurisdiction over the case within a given time period, the decision can be readily enforced without regard to territorial borders. Since a decision is generally issued within 2 to 3 months from the filing date, it is so much more efficient and inexpensive when compared with court procedures. The proceeding is quite fair as the panelists selected from all over the world possess special expertise and conducts the examination in a fair manner. This process also provides a recourse to the courts, unlike the arbitration.
Fantastic. That's an incredibly helpful overview, certainly for companies and potential users. And absolutely, I think what we see in our cases as the Hong Kong office of ADNDRC is exactly that. People are drawn to the efficiency of the process and the simplicity of it. As you say, the two outcomes, I think that it gives an element of certainty. And actually, in the cases that we handle, the transfer rate is high, well over 90%. So for a complainant, it does prove to be a very effective from both a time and cost and outcome perspective. And that's certainly our experience also. You touched there, Mr. Nahm, on the wide-ranging variety of panelists that we can appoint with specialist expertise. Talking about the role of the panelist, as I mentioned from the outset, you're certainly an individual with extensive experience, close to 800 or over decisions that you've rendered. What do you think makes a good panelist for a domain name dispute resolution proceeding? And also, in terms of the role of the service provider, what makes a good service provider?
Yes, I have written as many as more than 800 decisions as a panelist for UDRP or an examiner for URS on ADNDRC, NAF, WIPO, CHC, and IDRC. These days, I write 2 or 3 decisions a week. In a couple of years, it is expected for me to record 1,000 decisions. I write the decisions in 3 languages, English, Korean, and Japanese. Of 800 decisions I have written, 90% were in English and 10% in Korean and Japanese. All of my decisions are published at portal site of each of the service providers so that everyone can see the decisions. Once a specific case is assigned, a panelist renders a decision on a case similar to that issued by a judge. In this process, the panelist writes a decision more or less 10 pages, which provides in detail the reasons for the decision. The language used in this process is basically determined by the specific language that is used in the registration agreements. I think that providing good and persuasive reasoning by relying on established jurisprudence in a decision makes a good panelist. In doing so, panelists are required to be updated on the development and change of case laws and jurisprudence by regularly attending training sessions, seminars, educational programs, etc. Indeed, I have regularly participated with passion in the discussion of issues relating to Internet address dispute resolution as a panelist of ADNDRC, WIPO, NAF, and CAC. As to the role of the resolution service provider, such as ADNDRC, I think it is important to secure a good number of competent and multilingual panelists, as well as case coordinators, to provide opportunities to train and educate panelists and case coordinators, to provide efficient search tool for decisions or jurisprudence, to provide convenience for users, potential complainants and respondents, and to campaign public awareness or to promote its service for brand owners.
Yeah, no, thank you. I think that advice there, based on your experience in terms of producing a persuasive decision, is very important. And I think the languages that you mentioned also very important. Certainly on our panel, it's crucial to have obviously English, but given the region that we work in, it's also very important for us to have Korean speakers, Japanese speakers, and probably most importantly, currently for the Hong Kong office is to have those able to handle disputes involving the Chinese language too. So certainly language is an increasingly important theme, I think, for us in the Asian region. So it's very helpful to have panelists like yourself that are in fact multilingual, and multilingual in languages relevant to Northeast Asia. In terms of the service provider, I think the goal is to have a very competent and capable group of panelists, as well as the staff, again, with the requisite language abilities. So I'm glad that you raised those points, because there's certainly points that we look to strive towards. Moving on, and you touched on this a little bit in your first answer, but you are active, as you've said, in raising awareness of domain name dispute resolution, and also to have conversations about how to make it better with the various providers. You've touched on the advantages. Feel free to elaborate, but also, do you see any challenges to using this mechanism? Maybe not, maybe yes. And also, how best can we educate users to the advantages, or how to overcome any obstacles with this mechanism?
Yes, I have been very active in raising awareness of domain name dispute resolution. On numerous occasions, I wrote and published papers in this area, presented scholarly articles, conducted lectures, and wrote the Korean chapter of Domain Name Handbook, published by Oxford University Press. I am filled with joy to have contributed to the wider acceptance of the new method of dispute resolution that is different in nature from a simple mediation or arbitration. I wrote the book Challenging the 21st Century with Intellectual Property Rights, which was first published by Joseon Daily newspaper, one of the most read and most influential publications in Korea. I wrote this book in an easy-to-read anecdotal format, hoping to reach readers who may already be aware of the value and impact of intellectual property rights in our society, but still find the system and the law difficult to understand. I am grateful for the response to this book, as it was a bestseller at Kyobo Mungo, the largest bookstore in Korea. I wrote another book, Designing Your Own Unique and Dazzling Life. In my books, papers, and lectures, a special emphasis was placed on raising awareness of key advantages of ADR option for domain name dispute resolution. I kept emphasizing that the key advantages of ADR option are efficient, fair, and inexpensive procedures that enable companies and individuals with valid rights to cancel or recover the domain name registration that had been previously occupied or abused by cyber squatters. The ADR option has realistic merits for trademark owners for brand protection as compared with traditional ADR, which doesn't provide recourse to the courts, as opposed to mediation, which is not binding if either party is not satisfied, and compared with court procedures, which are expensive and time consumption. The ADR decision can be readily enforced without regard to territorial borders. We need to educate potential users to such extent. There is never a good idea to pay cyber squatters and to recover or cancel the domain name regardless of the amount, because cyber squatters are smart enough to offer for higher than the domain registration cost and equal to or cheaper than the dispute resolution costs through ADR. This is the challenge. However, since the cyber squatters would make money by their way, cyber squatting activities cannot be eradicated. In order to teach cyber squatters that they are not profitable, it is necessary to resolve dispute resolution through ADR, even if it would become more expensive than the price offered by cyber squatters, which would be less expensive in the long term. Until now, it can be said that global companies have dealt with this well, which has resulted in preventing cyber squatting to some extent.
Thank you. Just on your last point there, that companies are generally handling this threat well. I guess that takes us to the final question. So currently, companies are moving in the right direction, obviously, with their advisors and the dispute resolution options available to assist them. Moving beyond today, how do you foresee domain name dispute resolution in the future, in Korea, in the wider Asian region, and actually globally? I'd be really interested to hear your predictions.
A cyber squatter is a person who first acquires an internet domain registration in the form of a well-known trademark, product, or company name, and then seeks to sell the same registration with a hefty premium back to the original owner of the trademark or company who needs it to conduct business under that name. Not only do they make it impossible for companies who want to provide internet service to their customers under their desired domain name, but also this naturally leads to the abuse of extracting substantial payment from those companies. Further, there are those who use a name similar to a prior existing internet domain address to lure potential customers or efficient users to click on to porn sites or counterfeit product sites. The consequential damages from such cyber squatting activities then use such advertising sites as bait do not appear to be declining. As our cyberspace is ever expanding, I am predicting the domain name dispute will be increasing anywhere in the world, in Korea, Asian region, and globally. And thus the use of ADR option for domain name dispute will be increased accordingly. Lastly, I would like to emphasize that it is critical, especially for a company, to acquire an address for its virtual space that is the same as the name for the company or product. I would suggest to anyone seeking to survive and flourish in the high-tech 21st century to take an interest in IPR, intellectual property rights, floating through our world of virtual reality.
Yeah, absolutely. Fantastic, and completely agree with your predictions. The space is growing. It's certainly not shrinking. And I like the idea of surviving, but also flourishing within the environment. And so it is important, as you say, to pay close attention to this. And I think with individuals like yourself who have been raising awareness about this field for so many years, and who will continue to do so in ways that the consumer and the user can understand, we're in very good hands. But Mr. Nahm, thank you enormously for your time today and for sharing your insights and experiences and really your expertise so clearly with us. We really appreciate it, and we certainly look forward to working together and to hearing from you more in the increasing world of domain name disputes. But thank you very much, Mr. Nahm, and look forward to speaking to you again soon.
Thank you very much, Kiran. Thank you.